Telangana Chief Minister Sri K. Chandrasekhar Rao Garu for encouraging us in both the states, the ADR, and we are supported by both the governments, and the regional center is based at Hyderabad, for which I am the regional in charge and secretary. Friends, first let me take you through what is ICADR for initial 5 minutes. Good morning, friends. Most of you have seen this particular building based at Hyderabad, opposite to Gandhi Bhavan in Nampally. This is a regional center of the International Center for Alternate Dispute Resolution. In short, it is called ICADR. I have been acting as a secretary for both the states of Telangana and Andhra Pradesh. Once again, I thank you for APHRDI to giving me this opportunity. And you are looking at a bigger building which is based at New Delhi. This is our head office based at New Delhi, where our General Secretary Sri Rathore, R.K. Rathore ji sits. And on his behalf, I thank you, all of you, for giving this opportunity to speak on ADR methods. Friends, the International Center for Alternate Dispute Resolution was first established in India in 1995 by the former Prime Minister Sri P.V. Narasimha Rao, with the support of the Law Secretary Mr. P.C. Rao and the Law Minister Mr. H.R. Bharadwaj. It is an autonomous organization with its headquarters at New Delhi and having Hyderabad and Bangalore as the regional centers, and the Honorable Chief Justice of India is the chairman for ICADR institution. While this particular institution was inaugurated in 1995, the then Prime Minister has said few words while reforms in the judicial sectors were undertaken with necessary speed, whereas with necessary speed, it does not appear that the courts and tribunals will be in a position to bear the entire burden of the justice system. It is incumbent on the government to provide the reasonable cost as many modes of settlement of disputes as necessary to cover the variety of disputes that arise from time to time. Litigants should be encouraged to resort to alternate dispute resolution so that the court system proper would be left with a smaller number of important disputes that demand judicial attention. These were said while inaugurating our head office, New Delhi ICADR institution. Friends, the advantages of settlements through disputes is mainly saving the time and cost, and autonomy for the parties to a national and international disputes, choice of applicable law. Where I am saying the applicable law is the applicable law to this particular proceedings for arbitration is the Arbitration and Conciliation Act in India, and externally also worldwide, the unilateral body has given a model arbitration law for all the countries. So it will be a proper flow of same law applicable all over the world. Those who have signed the New York Convention, before that the Geneva Convention, and the recent past, the new conventions which have been happened subsequently with the nitty-gritty changes, all these people need to see that the applicability of Arbitration and Conciliation Act is in common with the unilateral model given, and that is where the applicable law comes into picture, and procedure and its language of the proceedings. Generally, the procedure will be the rules and regulations of the institutions like ICADR, SIAC, and ICA. Like these institutions will have a procedural rules and regulations, and also the language of proceedings. When you go to the court, you may see that the court is only administering through the local language. That may be the local language plus Hindi and English. But where in this alternate dispute resolution proceedings, you can adopt any language of your like. Like for example, if you know Gujarati, you both the parties agree, you can have Gujarati. If both the parties know Malayalam, they can do the Malayalam, and if both the parties know Telugu, they can adopt the proceedings in the Telugu. So these are the advantages of the settlement of disputes, where outside the court, when this particular usage of applicable law and procedures, very specifically these procedures for the institutions will be very strict, because you may find the institutions are administering the arbitration and mediation and conciliation, which follow the procedures like ICADR, which has been existing since 1995. You have rules and regulations. If you have any dispute other than criminal and also the service matters, you can have the disputes to be resolved under ADR methods. So the language of your choice will be more important for you. So you can have, when you go to the court languages are administered, whereas if you have the ADR methods usage, you can choose your own language in the proceedings. These are the flexibility of for you to usage, and also time. When you go to the court timings are from 10:30 to 5 o'clock. But whereas when you are using one of the ADR dispute resolution method, you can choose your own time. The parties together, along with the arbitrator or mediator, you can choose your own time. Either you can have in the morning, you can have in the afternoon, or you can have in the evening timings also. At the same time, the model laws are, the model costs are also has been published by government, and that are applicable to this. So these are the advantages where the usage of alternate dispute resolution. I will take you through what is arbitration and mediation and conciliation in my continuous presentation, but this is an introduction to the ICADR to you. The possibility of ensuring that specialized expertise is available on tribunal in a person of arbitrator, mediator or conciliator or a neutral advisor. If you go with any dispute to the court, you may find a lawyer who is becoming 99% as a judge, 1% other field people. But whereas if you go to the institution, you will find the persons of expertise like engineering, doctor, surveyors, chartered accountants, company secretaries. So you will find of your own issue specialized people who can be administering, or you can act as a neutral mediator. This is the advantage. When you go to the institution, they will be having a panel of people with them, and ICADR also has 6,000 people empaneled from different peoples, including judges, former judges, Supreme Court judges, and international expertise people also. And one more thing you may observe, it is strictly confidential when you are administering the ADR usage in the disputes for you. At the same time, the main objective of our institution is very specifically to provide facilities and administrative and other supports for holding the conciliation, mediation, and mini trials and arbitration proceedings. We generally give support to all the people, those who are adopting the ICADR rules and regulations for their disputes, including the mediation rules and conciliation rules. Also, we will be supporting by providing the facilities. We recently, after the COVID situation, started working in the international administration in arbitration and mediation also. This is the recent past change through virtual, where we have arbitrators, conciliators, and mediators such as experts in our panel to cooperate with the societies, institutions, and organization, national or international repute in pursuit of all our objectives. It is also our motto to cooperate and understand from their expertise. We go to the field visits and also see the new changes which are coming in and which can be adopted by our institutions also through resolution in our governing body. To draw up the prescribed rules of the institutions for different modes of ADR from time to time is the motto of ICADR and its objective. To promote the studies in the field of alternate dispute resolution, and also to undertake teaching and providing the diffusions of knowledge of law procedures of the ADR is the motto of ICADR. To impart training in ADR and related matters to those who are handling arbitration, conciliation, and mediation. Being part of the state government aided institution, we are supported by the state budgets, and we are referred all the matters of the government also to us through various departments so that we can administer the issues. The judicial department has already recommended in all departments in Andhra Pradesh and Telangana where the rules and regulations of ICDR can be followed. To promote the research and documentation in the field of ADR and public's books is the main avenue for one of the main avenue of ICADR. To organize conferences and seminars and study groups and the issue of concerning to ADR is also our main objective. ICDR has arbitration rules, conciliation rules, and mini trial rules which are available on our website. Friends, this is our reception in our regional center office, and where you will see our library, small library, who are supporting. We are supporting the engineers, doctors, chartered accountants, company secretaries, and the judicial officers, judges. All these people we are supporting for administering the arbitration and mediation. We also support the courts who are asking us from time to time for disputes arising out in mediation. We support them by through our alumni people who have passed out from our institution, and also with the empaneled people to support the resolutions for disputes arising out of arbitration and mediation. Those who do the usage of our institution for ADR methods, we support through this library, and time to time updated books are obtained. This is our administrative for arbitration and mediation halls, where the arbitrators and mediators sit here, and both the parties come here to do the disputes resolved. This is another room. We have 4 similar rooms now, and we have arbitrators and mediators room also here. We have a hall which we do the regular training courses, and also we do the post-graduation diplomas. We are tied up with many national law universities, and we also train the judicial officers of Andhra Pradesh and Telangana regularly here, and where the knowledge sharing will be done on arbitration, mediation, and conciliation with the supports of the local high courts. This is a mediation room where the parties will come and do the mediation process through our empaneled people, and also through the court and exit mediators, and through our alumni. We generally do the mediations here. Friends, ICDR, with the support of World Bank support and also the state governments, until now we have trained around 16,000 people from 1998 to 2017, either in the certificate course or as a post-graduation course, or different types of virtual programs, which we are proud to say that until today we have done 16,000 persons in this. And I'm also proud to say that I'm also alumni of this institution, and where many people like this who have studied the post-graduation here, and today I'm with the support of our governing council and our chairman, the Chief Justice of India, and our Secretary General, I have become the secretary for both the states of Andhra Pradesh and Telangana. We have tied up with Nalsar University and Nalsa National Law University Delhi, Jindal Global Law School, Damodar Sanjeevaya National Law University for the courses to be done in various locations. We have PG diplomas under MOU with these universities, where we have the regular courses conducted in our institution on the weekends, on Saturday and Sunday, and also we also do the correspondence courses, which are in regular mode and also through correspondence mode. We have PG ADR, PG FDR also. Friends, we also have tie-up with various national and international institutions, and few of these institutions are mentioned in the screen. Friends, we also have tied up with international chambers of commerce institutions like ICC, CIDC, and Indian Chamber of Commerce, with many more chambers of commerce where they require in the business side the support from us. Friends, through the World Bank project, we have been doing many programs, and using the World Bank support, our trainers went to the various countries for training in mediation and arbitration. In mediation training program, our trainers got CADR UK training, and also various workshops across the India. We also visited the leading arbitration centers during the study programs, and like Singapore International Arbitration Center, Singapore Mediation Center, and Effective Dispute Resolution CEDR, London Court of International Arbitration, Chartered Institute of Arbitrators, ICC Paris, and Permanent Court of Arbitration, Hague in Netherlands. This is part and parcel of our regular program which we do in association with other countries, and this very specifically we have done with the support of World Bank. With the World Bank, our ICADR trainers and other people, around 10 training programs we have could do it. Out of that, 362 people got trained in mediation, and 6 training programs conducted for arbitration. Around 150 persons have got trained. We also have international repute on our panel, and repute people including from London, US, and various other European and African countries, including from India, all are listed in front of you. We also have the judicial people, all including the recent Chief Justice of India who has been retired, and we also have all the Chief Justices and Supreme Court retired judges, and also High Court judges and lawyers, and many more repute of the people, including chartered accountants, company secretaries, and engineers who have retired as chief engineers. After their services, we are able to utilize on our empanelment to give services on the disputes where the applicable law is Arbitration and Conciliation Act 1996 as amended in 2015 and 2019. We also done reputed cases like HRD Corporation, Motorola Inc., Fixtg India Private Limited. These are few which I have just mentioned, and we are continuously doing in our court halls and outside also court. The people can adopt our rules and do the administration of arbitration, mediation, and conciliation, and the usage of alternate dispute resolution in this. Friends, you have seen our former chairman, late Sri H.R. Bharadwaj, and the Chief Justice of India at the time of our building inauguration, Sri Punch, and our former Finance Minister, Mr. Arun Jaitley, who have been inaugurating our building at Delhi on the Foundation Stone Day. Friends, with this, the introduction on ICADR I conclude, and I will take you through now the introduction to the ADR methods. Friends, once again, I welcome to the program organized by APHRDA on alternate dispute resolution methods. So we will be starting our main presentation now. Meeku Englishu మరియు తెలుగులో రెండిట్లో మీకు నేను అర్థమయ్యేటట్టు క్లియర్గా మన తెలుగు రాష్ట్రాలకి ఉపయోగపడేటట్టు రెండిట్లో కూడా మీకు నేను చెప్పడానికి మీ అందరికీ ఉపయోగపడుతుందని అనుకుంటాను. మీరందరూ చూస్తుండొచ్చు ఆల్టర్నేట్ డిస్ప్యూట్ రిజల్యూషన్ మెథడ్స్ అంటే ఏంటి. ఆల్టర్నేట్ డిస్ప్యూట్ రిజల్యూషన్ మెథడ్స్ అంటే నథింగ్ బట్ ఇట్ ఈస్ ఆర్బిట్రేషన్, మీడియేషన్ అండ్ కన్సిలియేషన్. అండ్ దిస్ 3 words టుగెదర్ తెలుగులో మన వాళ్ళు ఏమంటారంటే మధ్యవర్తిత్వం అంటారు. అంటే అన్ని కలిపి ఒకటే ఒక వర్డ్ మనం తెలుగులో ఉపయోగిస్తాము. ఆర్బిట్రేషన్ అయినా కూడా, మీడియేషన్ అయినా కూడా, కన్సిలియేషన్ అయినా కూడా. వెరీ స్పెసిఫిక్ గా ఈ ఆల్టర్నేట్ డిస్ప్యూట్ రెజల్యూషన్ మెథడ్స్ అంటే ఏమిటి అనే దాని మీద మనం ఫస్ట్ డిస్కస్ చేసుకుందాం. alternate dispute resolution అనేది it is a mean of addressing the settling the parties disputes outside the court traditional adversarial settings. Today alternative out of the court mechanism for settling the disputes are so effective that the courts often require parties to pursue these alternatives before litigating. Settling one dispute through a mechanism external to the court system may save your time and also money. ముఖ్యంగా ఈ ఆల్టర్నేట్ డిస్ప్యూట్ రిజల్యూషన్ సిస్టమ్ అనేది కోర్టు బయట మనము దీన్ని మన ఆర్బిట్రేషన్ అండ్ కన్సిలేషన్ యాక్ట్ మరియు మీడియేషన్ రూల్స్ ప్రకారము మనం కోర్టు బయట ఇవి అడ్మినిస్టర్ చేసుకొని టైం అండ్ సేవ్ ఆఫ్ మనీ ఈజ్ వెరీ వెరీ ఇంపార్టెంట్. అండ్ దిస్ పర్టిక్యులర్ mechanism of settling the disputes are so effective that courts often require parties to pursue this before coming to the court. అంటే మీరు కోర్టుకు వెళ్ళినప్పుడు ఒక లిటిగేషన్ కోర్టుకు వెళ్ళేటప్పుడు కోర్టు వారు కూడా ఈ మధ్యకాలంలో అడుగుతున్నారు మీరు ఆర్బిట్రేషన్ మరియు ఏదైతే మీడియేషన్ ఉందో మీరు దాన్ని ఉపయోగించుకొని కోర్టుకి లిటిగేషన్కి వచ్చారా అని చెప్పి. సో ఇది ముఖ్యంగా చాలా ఇంపార్టెంట్ మెకానిజం సో దట్ వేర్ పీపుల్ కెన్ యూటిలైజ్ దిస్ ఎక్స్టర్నల్ సిస్టమ్ అవుట్ ఆఫ్ ద కోర్ట్ అండ్ సేవ్ యువర్ టైమ్ అండ్ మనీ. You may be seeing people are sitting around 3 this side and 3 that side in between an arbitrator. That is where the arbitration proceedings happen. The person who is sitting in middle is an arbitrator. Manamu Telugulo madhyavarti antamu. Who are sitting besides 2 people are the lawyers or techno-legal lawyers or a chartered accountant who is practicing the arbitration or mediation, a company secretary or XYZ people. The 2 other peoples are the two people each on both the sides are the parties. So this is where how the arbitration and mediation happens. So very specifically, I am discussing about the arbitration. What exactly this arbitration is? Arbitration is a form of alternate dispute resolution, is a technique for resolution of the disputes outside the court, where the parties to the dispute refer it to one or more parties. That means who is named as an arbitrator and who is called as an arbitral tribunal. ఆ మధ్యలో కూర్చున్న ఎల్లో షర్ట్ వారు ఆర్బిట్రేటర్ గా వ్యవహరిస్తున్నారు, అది ఆర్బిట్రేటర్ ట్రిబ్యునల్ అంటాము. కాబట్టి by whose decision the award oblique a judgment they agree to be bound legally. By administering through the Arbitration and Conciliation Act 1996 and 2015 and 2019, adopting the act and usage of the institutional arbitration rules and regulations in arbitration and mediation and conciliation, the person who is sitting as an arbitrator will make both the parties for administering and getting it resolution so that the disputes can be resolved legally bounded. So I will also take you through mediation. What is the difference between arbitration and mediation? It is a resolution technique in which a third party reviews the evidence in the case of impose a decision that is legally binding for both the sides and enforceable. So that's what the arbitrators do, and arbitrator will be able to resolute through usage in a proper decision manner, which is legally usage of the act, and also with the rules and regulations of the institution, where he will be able to administer the arbitration and completes the arbitration proceedings and take a decision, and thus the award has been granted. It is in the form of award. It is other words called as a judgment. ఇప్పుడు మనము మీడియేషన్ గురించి డిస్కస్ చేద్దాం. ముఖ్యంగా మీడియేషన్ అనేది కూడా ఆర్బిట్రేషన్ ఏడిఆర్ మెథడ్స్ లో ఒక మెథడ్ అండి. ఇందాకట్లాగా మనం డిస్కస్ చేసాం ఆర్బిట్రేషన్, మీడియేషన్, కన్సిలియేషన్. ఇవి కాక 2-3 కోర్ట్ అనెక్స్డ్ సిస్టమ్స్ కూడా ఉన్నాయండి. లోక్ అదాలత్ కూడా మీకు ఏడిఆర్ మెథడ్స్ లోకి కన్సిడర్ చేసుకోవచ్చు. సో మనకి మీడియేషన్ అంటే ఏంటి అంటే ఇది ఒక మధ్యవర్తిత్వం. జనరల్ గా ఈ మీడియేషన్ ప్రొసీడింగ్స్ కోర్ట్ ఎనెక్స్డ్ మీడియేషన్ లోనే ఎక్కువ జరుగుతుంది. ఎందుకంటే ఈ కోర్ట్ ఎనెక్స్డ్ మీడియేషన్ కి వాళ్ళకే దీని మీద అధికారం ఉంది. మీడియేషన్ ప్రైవేట్ గా జరగడానికి ఇప్పుడు వరకు ఇండియాలో పార్టీస్ వరకు చేసుకోవచ్చు, కానీ అఫీషియల్ గా దానికి లీగల్ రికగ్నిషన్ ఉండదండి. ఇన్ ఫ్యూచర్, due to the Singapore Convention which has happened on August 7th on 2019, which is India is also a signatory for the Singapore Convention of Mediation. So in due course, the applicability of mediation to do the mediation outside the court may start, but until now it has been not started. So India is also signatory to that. So mediation can be done once the India has proclaimed this particular Singapore Convention, then the applicable mediation also can be done outside the court. So mediation is one of the ADR methods where a neutral and impartial third party, the mediator, who will be facilitate dialogue in structured multi-stage process to help parties reach a conclusive and mutually satisfied agreements. A mediator assists the parties in identifying and articulating their own interests, priorities, needs and wishes of each other. Mediation is a peaceful dispute resolution tool that is complementary to the existing court system and the practice of arbitration. చూసారండి మీడియేషన్ లో గొప్పతనము. ఆర్బిట్రేషన్ ప్రొసీజరల్ లా, అప్లికబుల్ లా యూజ్ చేస్తారండి. అది through Arbitration and Conciliation Act, whereas mediation has been through the process of Legal Services Authority Act of 1987, which is more court annexed. A neutral third person who is called as a neutral mediator, who will be not known to the both the parties until they go to the mediation center in the court annexed once the judge refers that to the mediation purpose for any litigation which has come before to him. So he will be acting as a neutral third person who are trained by the Supreme Court under the MCPC, and who will administer but for resolving through mediation process under section 89 of the Civil Procedure Code, implement usage of the section 89 through Civil Procedure Code, and he will be administering the mediation, bringing together the parties, both the parties for a win-win situation. అంటే రెండు పార్టీలు తన రూమ్ లో కూర్చున్నప్పుడు వాళ్ళిద్దరితోటి వాళ్ళ ఇష్యూని కనుక్కొని వాళ్ళిద్దరిని కలుపుకొని వాళ్ళిద్దరితోటి సొల్యూషన్ ఏంటో బయట పెట్టించుకొని వాళ్ళిద్దరితోటి అతను న్యూట్రల్ థర్డ్ పర్సన్ గా ఒక క్యాటలిస్ట్ గా వర్క్ చేసి, అండ్ హీ విల్ బి గెటింగ్ బోత్ ద పార్టీస్ విన్ విన్. అంటే both the parties will be able to conclude their own decision through mediation process, and both the parties will be winning situations in this. Nobody will be losing. So in this scenario, you will find that a third neutral party will be acting on this, and he will be administering the entire mediation process, and he will be also using a systematic and a disciplined procedural training which has been given to him. So it is very, very important that the neutral third party should get trained, and he is also the person appointed by the third party, third neutral person by the court, and it is a court annexed mediations in the mediation center, and where you will find he will be administering the entire mediation process, and in due course where he will bring both the parties for a conclusion, and where he will write a single one-page note to the judge in a confidential mode, and he will submit the report how both the parties concluded for a decision to resolve their issue. This is called a mediation. That is what you find a difference between arbitration and mediation. I'll also take you through the important differences also in the last page of this presentation. When you see the Arbitration and Conciliation Act, if you see Arbitration and Conciliation Act, you will see arbitration and conciliation available in this, but mediation is part of the court. So people were asking at that time, when the Arbitration Act was passed on in 1996, people were asking, when mediation there in the court, how can we do the mediation outside the court? Then a coin word has been brought out that is called conciliation. So conciliation is similar to the mediation process, which happens outside the court. People can do the conciliation outside the court as a part of the ADR methods. But one negativity is there other than the arbitration and mediation in the conciliation is at any point of a time during the conciliation, parties can withdraw and leave the conciliation process. That is the major disadvantage in the conciliation. That is why conciliation has largely failed in India. Conciliation is another dispute resolution process that involves building a positive relationship between the parties of disputes. However, it is fundamentally different from the mediation and arbitration in several aspects. The conciliator is an important person that assists the parties by driving their negotiation and directing them towards a satisfactory agreement. It is unlike arbitration in that conciliation is a much less adversarial proceedings. It seeks to identify a right that has been violated and searches to find the optimum solutions of the issue. That means when the conciliation happens outside the court, here the conciliators take a decision, whereas in the mediation, both the parties take a decision. When both the parties are together in the conciliation process, the conciliator will take a decision. So that means it is little bit model different between the mediation. So in between also, if both one party do not like the conciliation process, they can withdraw. So that is why the conciliation has largely failed in India, but still it is going very successfully in government and also in the public sector and in other forms where still people are using, which is part of Arbitration and Conciliation Act 1996. A clever person solves a problem, a wise person avoids it. This was said by Albert Einstein. A clever person always solves the problem, but wise person avoids. That means a clever person, you may be in government, so you may be the person who is losing your money, he will try to resolve the issue. But whereas if you find a party where he's a business people, he will always try to avoid that and use your money for their business purposes. I will also show another proverb in my last slide of presentation. Friends, you could have seen two parties are fighting each other, where you will find arbitration with one party agreement clause is there, other party is agreement clause is not there. So the person who is acting as a neutral person, as an arbitrator, he is trying to make them silent and ask them to use the arbitration clause. Arbitration is a proceeding which a dispute is resolved by an impartial adjudicator whose decision the parties to dispute have agreed or legislation have decreed will be final and binding. If an arbitration proceedings happens, the impartial adjudicator who has been appointed by both the parties. Friends, you may find another important surprise in this act. Generally, in the courts, the judges are appointed by the courts. That is either by the chief judges of the High Court or by the National Judiciary. Where here, the one peculiarity is that you yourself can recruit a judge who can act as an arbitrator to you. This is a wonderful opportunity for you. Whenever there's a dispute comes, you try to have in the agreement the arbitration clause. If the arbitration clause is mentioned that if both the parties agrees with an adjudicator who is called arbitrator, then you can appoint, both the parties can appoint the arbitrator and can be done in arbitration proceedings where there is no involvement of court. Just see how big surprise it is. Where you could have seen here a party who has been standing అంటే మనం తెలుగులో ఎడమొఖము పెడమొఖం అనుకుంటాం. There is a gap between these two. A dispute has realized they are not willing to see or bridge the gap. At least try to see each other, no way. they got an arbitration clause. So once they have the arbitration clause, both the parties can meet each other, can resolve their disputes. That is the importance of clause in the any agreement or contract. Friends, see how the dispute arises. When the dispute arises, if the contract and arbitration clause is there, both the people at the end are getting shaken hands. Whereas in the brawl, both the parties are fighting each other, they do not have the arbitration clause. They are saying get lost to each other. So that is where the business disputes or contract disputes or any other disputes can be resolved once you have clause in the contract or an agreement, or separately if both the parties can write on a white paper. If you have an individual dispute also in the court and submit to the court, you can resolve the issue by mentioning the usage of arbitration or mediation outside the court also. So this is also can be done whatever the litigation pending in the court also currently, and the disputes which are arising you can use through your contract agreements. Friends, just to brief you what is contract and agreement. This is only one small introduction to you. You find a contract is an agreement having lawful object entered into a voluntary by two or more parties, each of whom intend to create one or more legal obligation between or among them. The element of contract always have two things, that is offer and acceptance by competent persons having legal capacity who exchange the consideration to create mutuality of the obligation. That means every contract or an agreement has offer and acceptance. So without offer and acceptance, no contract or agreement will be there. So the work will be offered to other party and acceptance by the other party to do the work. So when the offer is been given, it is always in the money side, and when the acceptance is given on the work side. So generally this is the mode which happens through the contracts and agreements. Why do we contract? To achieve our goals with the help of others, to share the risk with others, to minimize the risk by outsourcing certain activities for others to perform. These are the offers and acceptances where a contract always will have. This is where we work for through a contract. Friends, if you see the value of the money, time also is very important. So time value of money is always very important. If you see the top building, it is worth 50 lakhs today. If you see the same 50 lakhs building after 5 years, how small it has become. The same 50 lakhs after 10 years, how small still it has become. So time value of money is very important for everyone, including business and also individuals. So let us not fight the disputes in the courts, where court is already overburdened with the rules and regulation interpretation issues. So we should adopt the ADR methods, that is alternate dispute resolution, to save our time and also to save our money also by resoluting this particular issues whatever comes arise from time to time. Why do we need the disputes to be resolved? Yes, there are two facts. That is, one is disputes can make damage if left unsettled immediately. Arbitration is one of the disputing settlement mechanism permitted by law. సో మధ్యవర్తిత్వం అనేది ఏదైతే మనం ఉపయోగిస్తున్నామో వేరియస్ ఫార్మ్స్ లో, ఈ మధ్యవర్తిత్వాన్ని మనకి రైజ్ అయిన డిస్ప్యూట్స్ అయినా క్లెయిమ్స్ అయినా ఏవైనా రెండు పార్టీలు అగ్రి అవ్వకపోతే ఆ రెండింటిని అదర్ దెన్ క్రిమినల్ కేసెస్, అదర్ దెన్ సర్వీస్ మ్యాటర్స్ మనము కోర్టులకే వెళ్ళక్కర్లేదు. కోర్టు బయట కూడా ఈ డిస్ప్యూట్స్ ని, ఈ డ్యామేజెస్ ఏవైతే ఉన్నాయో ఆ క్లెయిమ్స్ ని రెండు పార్టీలు కూర్చొని వాళ్ళు ఒక లీగల్ ఫ్రేమ్వర్క్ తోటి వాళ్ళు కోర్టు బయట కూడా మాలాంటి ఇన్స్టిట్యూషన్ ICADR మరియు వాళ్ళు సొంతంగా కూర్చొని మా రూల్స్ అడాప్ట్ చేసుకొని ఏ ప్రదేశంలో అయినా కూర్చోవచ్చు, ఏ టౌన్లో అయినా కూర్చోవచ్చు, ఏ సిటీలో అయినా కూర్చోవచ్చు. వాళ్ళు మా రూల్స్ అండ్ రెగ్యులేషన్స్ ని అడాప్ట్ చేసుకుంటే చాలు. చేసుకొని వాళ్ళు డిస్ప్యూట్ ఉన్నప్పుడు దాన్ని ఫాలో అవుతూ వాళ్ళు పర్టికులర్ ఇష్యూస్ ఏవైతే ఉన్నాయో దాన్ని మధ్యవర్తిత్వం ద్వారా 3 రకాల మధ్యవర్తిత్వం ద్వారా ఉపయోగించుకుంటూ వాళ్ళ డిస్ప్యూట్స్ ని వాళ్ళు తొలగించుకోవచ్చు. అదే విధంగా మనం ఇందాక నుంచి డిస్కస్ చేస్తున్నాము ఈ ఏడిఆర్ మెథడ్స్ ఎన్ని ఫార్మ్స్ లో ఉన్నాయి. ఈ ఏడిఆర్ మెథడ్స్ అనేది మనం ఇందాక డిస్కస్ చేసిన దాంట్లో ఆర్బిట్రేషన్ డిస్కస్ చేశాము, కన్సిలియేషన్ డిస్కస్ చేశాము, మరియు మీడియేషన్ గురించి డిస్కస్ చేశాము. అదే విధంగా ఈ నెగోషియేషన్ అనేది జనరల్ గా మనకి పబ్లిక్ సెక్టర్ లో వాటిల్లో విచ్ ఇస్ పార్ట్ ఆఫ్ ది ఏడిఆర్ ఓన్లీ విచ్ ఫాల్స్ ఇన్ ద ఆర్బిట్రేషన్ అండ్ కన్సిలియేషన్ అండ్ మీడియేషన్ ఆల్సో. అదే విధంగా కొన్ని కార్పొరేట్స్ లో కొన్ని కంపెనీస్ లో డిస్ప్యూట్ రిజల్యూషన్ బోర్డ్స్ అని ఉంటాయి. ఈ డిస్ప్యూట్ రిజల్యూషన్ బోర్డ్స్ అంటే మీ సూపరింటెండెంట్ ఇంజనీర్ గారో, మీ చీఫ్ ఇంజనీర్ గారో, మీ బోర్డ్ ఆఫ్ డైరెక్టర్స్, లేకపోతే మీ మినిస్టర్ గారో, లేకపోతే ఎవరో ఒక బోర్డు ఒకటి ఫామ్ అయ్యి ఉంటుంది. ప్రతి దాంట్లోనూ ఆ బోర్డు ద్వారా కూడా మీ ఇష్యూస్ ని మీరు రిజల్యూషన్ చేసుకోవచ్చు. Now let us go through how arbitration is benefit over litigation. Can some of you unmute the speaker and tell me? Until now we have discussed many things. What will be the advantage of arbitration over litigation? Can you please tell? I will type. Sir, can some of you can unmute and talk to us? What is the advantages of arbitration over litigation? Hello? Can some of you tell what are the arbitration advantages over litigation? Faster than the litigation. At least now you can tell us. Can some of you unmute and tell what are the arbitration advantages over litigation? No one is answering to me. అందరు మ్యూట్ చేసి పడుకుంటున్నారు. Acha, okay. So I could understand that there is a problem in unmuting yourself. So he cannot unmute. So now I will take you through what is the advantages of arbitration over litigation. Huh? Yeah, flexibility and time. Just type it. I will be able to observe your things. Enforceability. Yes, excellent. Yes, please continue. Please write in the chat. Party autonomy. Excellent. You are all coming near to me. Save time and cost. Excellent. Time saving. Excellent, sir. You're all coming to the. I'm going to type what you said. The confidential and time consuming. Excellent, sir. I'm very happy that you are able to understand ADR. Yes, sir. Some more answers. Please be active, sir.
Hello, sir.
Yeah, please speak, madam.
Sir, when we are talking about arbitration and we are comparing it to traditional litigation, the best thing is that it is extremely time saving. For example, Arbitration Act is saying that if we are going for arbitration, it has to be completed max to max within 1 year. And if we are going for fast track arbitration, then even the time period provided is 6 months. So this is one of the most important benefits, that the time period of 1 year or 6 months. And
Madam, yes, madam, yes.
And then as you also discussed, like there is complete confidentiality of the parties. So whatever parties are discussing, that remains confidential. And even when the award is being made, if the parties want that certain information should not be part of the award, even the parties can go ahead and put a request to the arbitrator that please don't include these kind of particular information within the award, and the arbitrator will listen to that. So primarily that time saving, which will also lead to money saving, and that parties can have it completely confidential according to their own rules regulation. Like you were talking about language, so whichever is their regional language, place wherever they want to do, whenever they want to do, whatever method or procedure that they want to take, be it evidence, everything the parties can go ahead and decide. It's almost as if you
Thank
have
you,
to
Asha.
say
Thank
in
you.
how you're
And
deciding.
few more people can test.
Hello? Hello, sir.
Yes, sir. Yes, sir.
Sir, in the case of court system, there is restriction of time. But in the case of arbitration and mediation, there is no restriction of time. So they can be available at any time, any given time, given point of time depends upon the parties and also mediation. But court is not like that. It will become on the court will declare. What time will declare the time only the parties should go and attend the court. But arbitration system is not like that. Whenever the parties are flexible and whenever the parties are interested to speak themselves, then definitely they will go.
Yes, Ravichandra Garu, I agree with you.
Yes, sir.
But one thing Asha madam was also saying that there is a time limit for arbitration need to be completed max to max 18 months. And similarly, in doing a mediation process, it is minimum of 3 months. It can be extended by the court also. So Ravichandra Garu, I will explain you in detail in due course about this, but the flexible timing during the daytime is right. That means you can have the hearing anytime in the daytime. So it is either in the morning, afternoon, or evening. At the same time, the appointment of judge, in other words, arbitrator, can be done by both the parties. Thank you, Ravichandra Garu. You and Asha Madam also has told. If any other people can say any more, please let me know. I will type the same.
Good morning, sir.
Tell me, madam.
So I would like to add one more thing.
Yes,
so
madam.
here, because of the ADR methods, so
Yes.
parties are having a more control over the process and the results. So, so this is also one of the advantage, according to my knowledge.
Sir, shall I speak, sir? Shall I speak, sir? Hello.
Please.
Sir, it is a facilitating process to the between the parties also. As a mediator, we had to facilitate the parties to solve the problem. And it is within a time limit also. Time has been shorted and the money also saved for the parties. And it is a win-win process, sir. It is a win-win process also as a mediator, because we can facilitate the parties to solve the problems so easily within a time duration. It can be solved, and we can send the report to the judges, and it will be the final, and it cannot be appealable also, and the cost also refunded to the parties.
Murthy garu, could I speak?
Correct, madam. Correct.
Thank you, sir. Thank you. Thank
Yes,
you.
sir. Yes, sir.
Sir, if I add,
Jaya Patel. I am Jaya Patel, sir. Jaya Indra Patel. I am from Madurai, High Court. High Court. Yeah.
Thank you, madam.
sir,
Thank
if
you.
I could just,
As mediator. Okay. Thank you, sir. Thank you, sir.
Thank you, madam.
sir,
Thank
if
you.
I could add
Thank you very
one
much, sir.
thing,
Thank you.
sir, if I have your permission and I could add something,
Please.
for arbitration, parties have the right that if for any reason they are not happy with the arbitrator, they can change. That is also a big advantage. Probably you are not happy with how judge is handling your case, but you are stuck. Max, it will go for 10 years. You go in appeal and you just pray to God that the appellate judge is better. But for arbitration, if for any reason you are not happy, he is not listening or he is not considering things on merit or whatever. The thing is, parties are not happy with the arbitrator. There is a mandate for termination of. There is a provision for termination of mandate of arbitrator. You can go and change the arbitrator. So that gives the parties a lot of say on how things go, because ultimately it is their dispute, it is their money or their problem. So they should have that stake in how it gets decided and who decides it.
I agree, madam. I agree with you, but few instances are there for like this. But generally, what you said is right. But because of the 18 months, max to max 18 months usage, so where now I think the rescue of the arbitrators are becoming very less. But at the same time, there have been certain forms, disclosure forms have come in place. So even the arbitrator, before he starts the arbitration proceedings, I will share with you in due course in my next presentation in continuation, madam.
Thank you, sir. Thank you, sir.
Thank you, madam.
Murthy garu, could
Sir,
I speak?
చెప్పండి సార్.
Karan Kumar, I am Karan Kumar, DLS Secretary Chittoor.
నమస్తే సార్, చెప్పండి.
Namaste, namaste. Murthy garu, but this arbitration and mediation is a failure at primary courts. I think the person proactive like you must get these things down to the ladder to be implemented more so in the primary courts, because this arbitration and mediation is a failure in the primary courts. So if you could take this ladder down the line, more and more cases will be settled amicably, and that there shall be tranquility in the society. You must consider this.
I agree, sir. Ashok Kumar garu, I totally agree with you. I have done one program for the legal, all the judiciary people at Chittoor. 2 times I have done. And one more thing, sir, just mentioned this to your member secretary of the AFI, and I will certainly come down even to train your volunteers.
My request, Murthy garu, to bring the ladder down to the common man throughout India, not in Chittoor only.
Sure, sir, sure.
Most of the people, they don't know what is mediation, what is arbitration. They are not exercising their option over it.
I agree, sir. I agree, sir. I totally agree with you. And I am there to with you. I will certainly come down and do the services. And I will also speak to your member secretary and see that the implementation happens all over India, sir. Thank you very much, sir.
So far as CPC is concerned, CPC, the Code
Thank
of
you,
Civil
sir.
Procedure.
Yes,
Code
sir.
of Civil Procedure is concerned, no, judges are exercising, less what we call discretion in settling the matters and actively participating in the process of mediation. That is also there.
Sir, I agree with you. We also need to bring the training program to down the level, and we will certainly do that work, sir. Being the institution working along with the AP High Court, we will certainly do that services, sir, and bring it to the notice of the member secretary.
Hello, sir. I am Ravichandra here, sir.
చెప్పండి రవిచంద్ర గారు.
Sir, నేను విజయనగర్ లా కాలేజ్ స్టూడెంట్ అండ్ ఆల్సో డిఎల్ఎస్ పిఎల్వి మెంబర్, సార్. అనంతపురం డిఎల్ఎస్ లో పిఎల్వి మెంబర్ కూడా, విజయనగర్ లా కాలేజ్ స్టూడెంట్ కూడా. ఇక్కడ మీడియేషన్ సిస్టమ్ లో కానీ ఆర్బిట్రేషన్ సిస్టమ్ లో కానీ ఫస్ట్ ఆఫ్ ఆల్ మనము పార్టీస్ కి చాలా ఈజియెస్ట్ గా ఉంటుంది సార్. కోర్ట్ అంటే లెంతీ ప్రాసెస్ ఉంటుంది. అదే ఆర్బిట్రేషన్ మీడియేషన్ సిస్టమ్ లో మనం తొందరగా రెజల్యూషన్ అనేది ఇవ్వచ్చు. రెండోది ఇది విన్ అండ్ విన్ ప్రాసెస్. అక్కడ ఎవరో ఒకరు ఓడిపోవడం అనేది జరుగుతుంది, కానీ ఇక్కడ ఇద్దరిని గెలిపించేటటువంటి ఆసక్తి అనేది మీడియేటర్ లో ఉంటుంది. సో ఇక్కడ ఇద్దరు కూడా నష్టపోరు, పార్టీలు ఎవరికి కూడా నష్టపోరు, వాళ్ళ పర్సనల్ గెడ్జ్ అనేది కూడా ఉండదు. అదే కానీ మనం కోర్టు ప్రాసెస్ లో ఏంటంటే ఎవరో ఒకరు నష్టపోతారో, ఏదో ఒక పార్టీ ఓడిపోతారు. కానీ ఈ సిస్టమ్ ని మనం ఈ సొసైటీలో, ప్రజెంట్ ఉన్న సొసైటీలో మీడియేషన్ కానీ ఆర్బిట్రేషన్ కన్సిడరేషన్ సిస్టమ్ ని ఎంత బాగా డెవలప్ చేస్తే మనకు ఈ నవ సమాజ నిర్మాణంలో మనం కొంతవరకు ఈ జ్యుడిషియల్ సిస్టమ్ ని కాకుండా ఇటువంటి సిస్టమ్ ని ఏర్పరచుకోవడానికి చాలా బాగుంటుంది నా వ్యక్తిగతమైనటువంటి అభిప్రాయం, సార్.
తప్పకుండా సార్, మీరు అన్నది నేను 100% నేను అంగీకరిస్తాను. మీరు చెప్పేది కూడా నేను మీరు చెప్పింది కరెక్ట్ చెప్పారు 100%. మీరు అన్నట్టు సమాజంలో దీన్ని తప్పకుండా ఉపయోగిద్దాము. దీన్ని మనం గ్రౌండ్ లెవెల్ అశోక్ గారు అడిగినట్టు మనం గ్రౌండ్ లెవెల్ తీసుకుందాము. వేర్ సేవింగ్ ద మనీ ఇస్ ఆల్సో వెరీ ఇంపార్టెంట్. Now shared with me the main advantages which I have already typed. I will just share with you. Please kindly mute yourself.
Thank you, sir.
Thank you.
Sir, my name is
చెప్పండి కరుణ కుమార్ గారు.
గుడ్ మార్నింగ్ సార్ మూర్తి గారు.
చెప్పండి కరుణ కుమార్ గారు. సార్ చెప్పండి. గుడ్ మార్నింగ్.
గుడ్ మార్నింగ్ సార్ మూర్తి గారు. I'm P. Srinivasarao,
sir,
trained mediator and trainer from Rajahmundry, nominated by Supreme Court of India MCPC.
Yes
Sir, you have explained the ADR system in a very vivid manner, sir.
Thank you.
We are the trained mediators doing mediation in Rajahmundry and other places in East Godavari.
Sir.
I am also a trained mediator nominated
Sir.
by MCPC, Supreme
Sir.
Court of India.
Sir.
Sir, we have vividly explained the differences between the Lok Adalat, arbitration, negotiation, mediation, and conciliation. Thank you very much, sir, for your explaining capacity. You are very intrinsically differentiated these four forms. Thank you very much, sir.
Thank you once again, sir. Thank you once again.
Thank you.
Sir, I'm
Can you mute all the speakers, please?
speaker.
అమ్మ భాగ్యలక్ష్మి గారు ఎక్కడి నుంచి అమ్మా?
Rajahmundry, sir, I'm also a mediator and trainer.
తెలుసమ్మా, మీరు నాకు తెలుసమ్మా. చెప్పండి అమ్మా. నమస్తే అమ్మా.
Namaste, sir. How are you, sir?
వెరీ ఫైన్ అమ్మా. చెప్పండి అమ్మా.
Sir, implementation లేదు సార్. మన ADR సిస్టమ్ స్ట్రిక్ట్ గా ఇంప్లిమెంటేషన్ లేదు ఫ్రమ్ బాటమ్ ది కోర్ట్ నుంచి.
అవునమ్మా, అదే
ఈవెన్ మనం ఎంత చేసినా ఇంప్లిమెంటేషన్ అంటిల్ అన్లెస్ ఇంప్లిమెంటేషన్ లేకపోతే చేయడం చాలా కష్టం సార్. మనం ఓన్లీ థియరిటికల్ గా చెప్పడం కాదు, ప్రాక్టికల్ గా వీ హ్యావ్ టు ఇంక్లూడ్ జడ్జెస్ జ్యుడిషియల్ ఆఫీసర్స్ ఆల్సో టు ఫార్వర్డ్ ద కేసెస్ అండ్ సీ ద ఇంప్లిమెంటేషన్ సార్.
yes అమ్మా.
అన్లెస్ ఇంప్లిమెంటేషన్ లేకపోతే మనం ఎన్ని చేసుకున్నా వేస్ట్ సార్.
అమ్మా, నేను ఆల్మోస్ట్ ఆంధ్రప్రదేశ్ అండ్ తెలంగాణలో జడ్జెస్ కి ట్రైనింగ్ ఇచ్చానమ్మా. టైం టు టైం రిఫ్రెషింగ్ కోర్స్ కూడా చేస్తున్నాను. ఎప్పుడైతే రిఫ్రెషింగ్ కోర్స్ చేస్తానో, ఫర్ ఎగ్జాంపుల్ మీరు రాజమండ్రి నుంచి మాట్లాడుతున్నారు. రాజమండ్రి ప్రిన్సిపల్ డిస్ట్రిక్ట్ జడ్జ్ కోర్టులో నేను రిఫ్రెషింగ్ కోర్స్ చేస్తున్నప్పుడు 50% మీడియేటర్స్, ఫ్యూచర్ మీడియేటర్స్ వాళ్ళని కూడా 50% పెట్టి, జ్యుడిషియల్ జడ్జెస్ ని 50% పెట్టి ఈ ట్రైనింగ్ ప్రోగ్రామ్స్ చేస్తుంటానమ్మా. తప్పకుండా నేను రాజమండ్రి వస్తాను, మెంబర్ సెక్రటరీ గారితో మాట్లాడతాను, హైకోర్టు చీఫ్ జస్టిస్ గారితో మాట్లాడి తప్పకుండా మీరు ఏదైతే అంటున్నారో దాన్ని ఇంప్లిమెంట్ చేయడానికి నేను నా వంతు సహకారం తప్పకుండా అందిస్తానమ్మా. థ్యాంక్ యూ అమ్మా. థ్యాంక్ యూ భాగ్యలక్ష్మి గారు. అండ్ కెన్ ఐ
హలో
చెప్పండి శ్రీనివాస్ గారు.
హలో
శ్రీనివాస్ గారు
హలో
చెప్పండి. హలో సార్.
సార్, గుడ్ ఆఫ్టర్నూన్ సార్.
సార్
ఐ ఆమ్ ఫ్రమ్ కోవూరు.
చెప్పండి సార్.
సార్, ఐ ఆమ్ అడ్వకేట్ హియర్.
ఎస్ సార్.
నెక్స్ట్ ఐ ఆమ్ లీగల్ advisor also.
ఎస్ సార్.
This is ADR system is one of the subject in law studies also, sir, 3 years course.
Yes sir.
Sir, this is a completely pure transparent method, sir.
Yes.
There is no hiding anything between parties and the arbitrator, sir.
Yes.
But actually, this was not in progress nowadays.
Sir.
Hello. Sir, I am Mahibullah, sir. Yes, sir. Because it is the duty to government to uplift the method to in all courts, sir.
I agree, sir. I agree with you. That is why today this webinar is been conducted supported by the APHRDI, and I
Yes,
totally
sir.
agree with you. Yes, in the districts also, I will speak to the High Court people and see that in the districts also these webinars are conducted, sir.
Okay, sir. Thank you very much, sir.
Thank you.
Could I speak? Murthy garu, could I speak?
Yes, sir. Yes, sir.
I am Karun Kumar, DLS secretary.
Sir, namaste, sir.
Murthy garu, there is also a misnomer among the people that the arbitration system is a huge burden financially.
No, sir, not at all, sir.
That misnomer should be ward off.
Yes, sir. Certainly, I agree with you, sir.
Please take reasonable steps, sir, to ward off this misnomer.
Sure,
Also,
sir.
ADR
Sure,
system
certainly.
is burdensome.
Yes, sir. Certainly
Thank you,
we
sir.
will do that. Thank you,
Thank
sir.
you.
Thank you. I'm going ahead with the presentation. I thank you for all of you giving an opportunity and sharing your thoughts on advantages of arbitration over mediation, over litigation, and also on the mediation also you have given me. So I 100% concur with your thought process. We will bring it to your lower courts and also to the common man this particular process, and we will see that it will be implemented, and I will take full steps to take these steps with the support of the member secretary also of each high court and also the state governments who are funding to us. So friends, now I will be taking you whatever you have said to me until now. I am going to just, I have already typed, arbitration is often faster than litigation, cheaper and more flexible for business. When the dispute is highly technical, arbitrators with an appropriate degree of the expertise can be appointed. That is, one cannot choose a judge in a litigation in the court. But whereas when the arbitration proceedings, you can even take the people as an arbitrator who is technical person with appropriate degree of expertise. This is one more very big advantage of arbitration over litigation. You'll also find proceedings of an arbitral award are generally non-public and can be made confidential. These answers were just now told by you only after hearing to my first phase of the hearing, first phase of my presentation. Flexibility to choose the language, any language, Malayalam, Gujarati, Telugu, sitting in Hyderabad, sitting in Visakhapatnam, sitting in Vijayawada also, you can adopt any language for the arbitral proceedings. At the same time, you can also go with the official languages, and at the same time the competent court will automatically apply wherever you do the hearing proceedings. Arbitrators awards are generally easier to enforce in other nations than court judgments. When you see the court judgments which are within the district, within the states, it can be implemented, whereas an arbitral award can be implemented anywhere in the world. This is the peculiarity of the arbitration award cum judgment. Limited avenues and recourse of the arbitral award, which is sometimes an act because it limits the duration of the dispute and any associated liability. So arbitration need to be, after 2015 amendments, need to be completed within 18 months max. So friends, with this, the major advantages which are in arbitration have been shared with you now, and which are said by you only. So I will just take you through what all the important parts in the arbitration proceedings generally happen. There are 2 to 3 areas of the people who generally support in the arbitration proceedings. That is, as a consultant to explain, opine, and witness. That means consultants from the law firm, experts, advocates, and experts, engineers, experts, various fields, judicial judges, all these people who can explain, opine, and witness. Second is counsels, lawyers, engineers, chartered accountants, company secretaries, who can help, present, and assist in the arbitration proceedings, who can act as a counsels. Experts to explain, opine, advise, and scrutiny. Ante very specifically during the proceedings of arbitration, we may require a technically highly standard people who will give a report where arbitrator can ask both the parties to share the opinion money, and they can ask the, for example, a dam is been constructed. When the dam is constructed, what is the technicalities in that? So somebody can be a third party, can be put up as an expert and take his opinion. At last, finally, the arbitrator who can decide and give an award in form of a judgment. Thanks for this mess. You have created under your own contract a clause that is arbitration. Friends, if you see the right side, a man has been tied up and 3 people are taking the gun and trying to shoot him. Yes, the man is asking us who has been tied up with the pillar, why I am tied up here. The 3 persons are telling that you have a clause of an arbitration in your agreement. That is why you have to compulsorily go through the arbitration proceedings. So friends, this is what various professional line of working also there in the arbitration side, which is very much implemented and which can been happening from years together. After my first proverb, now I am sharing with you. If you can't explain it to a 6-year-old, you don't understand it yourself. So I myself need to question myself that whether I have properly able to explain to you, and at the end I'll ask the feedback on this. Friends, as you all said, the differences between arbitration, mediation and conciliation. Now I have prepared a chart of the where you will find the comparison. Very specifically, what is the differences between the various judicial versus ADR proceedings. I am just comparing point wise with judicial process, arbitration, and the third one is mediation. In judicial process is an adjudicatory process, and where a third party, judge or other authority decides the outcome. Whereas in the arbitration is a quasi-judicial adjudicatory process where the arbitrator appointed by the parties decides the dispute between the parties. So just understand the difference between will be able to the same parallels process and not an adjudicatory process directly in the resolution and declare the terms of settlement. So it is a win-win situation. As Bhagyalakshmi madam was telling, yes, it is a win-win situation. So both the parties will decide together and they will come out with a solution, and negotiator who is acting as a neutral third party, he will look into that whether it is proper or not, and then he will prepare an agreement of mediation, and where it has been concluded on what basis the resolution has been happened, then he will submit to the court, and the court, honorary district legal secretary or the other judges who have assigned this mediation will take a decision whether something wrong in this particular process happened or any legalities are there. He will examine and he will pronounce the judgment in any other court. That means if the process happened in district court, it cannot be contested in high court, it cannot be contested in Supreme Court also. Procedure and decisions are governed by the provisional of relevant statutes, that is in the judicial process. Arbitration, procedure and decision regulated by Arbitration and Conciliation Act 1996 and Amendment Act 2015 and 2019. In mediation, procedure and settlement by any statutes, except in the finality where judgment has been pronounced, it acts with under the rule of Act of Section 89 of Civil Procedure Code, where the mediation process were completed. Friends, again I am taking you through the three differences. Judicial process decision is binding on the parties, and arbitration award is binding on the parties. Mediation, a binding settlement is reached only if parties arrive at a mutually acceptable agreement. In judicial process, adversarial in nature, focused on the past event and determination of the rights and liabilities of the parties, which in the judicial process happen, whereas in the arbitration, adversarial in nature, focuses on past events and determination of the right and liabilities of the parties in the decision making happens in the arbitration. Whereas in the mediation, you find a different phenomena. Collaborative in nature, as it focuses not more on the present, but it focuses on future resolution of the dispute by mutual agreement. Friends, point number 5. In judicial process, personal appearances or active participation of parties is not always required. Yes, similarly, in the arbitration also, personal appearances or active participation of the parties is not always required. Whereas in the mediation, it is different. Personal appearances or active participation of parties is always required. This is what the differences between judicial process, arbitration, and mediation. I will also take you through mediation, conciliation, and also Lok Adalat in due presentation. If you see in the 6th point, a formal proceedings held in public and follows the strict procedural stages. Whereas in arbitration, a formal proceedings held in private, which is confidential now, and follow the strict procedural stage. Whereas in the mediation, a non-judicial and informal proceedings held in the private, who will act as a neutral third party who has been trained by the Supreme Court in the MCPC training for 40 hours for 5 days training program, who are recognized mediators in every court, Just now, our friends who have been speaking to me, or most of them are the mediators from different locations in Andhra Pradesh and Telangana. A non-judicial and informal proceedings held in private with flexible procedural at stage by stage, who have been trained in a very disciplined and step-by-step manner, and also to conclude in a staged manner of the negotiation by both the parties, and who will act as a catalyst is the mediation role, who will not give the judgment for both the parties in the mediation process. He will make both the parties. Just think of how difficult this particular process to be. I will just tell an example to you. Whenever I have been doing this mediation, initially in the first stage, first 5 minutes, both the parties are shouting at each other. I am the third person neutral to both of the parties. I do not know until they came into my room. The situation will be like that both the parties 5 minutes shouting on them. But it is the mediator duty to bring them and take the control. It is very difficult process, because I have been the mediator training to all the judicial officers and most of the mediators and many more. It is very, very difficult situation, but mediation is the most successful method among all the three, which can be resolved max to max 3 to 6 months. Friends, I will be discussing about the judicial process, arbitration and mediation, where you find a judicial process is decision is appealable, and arbitration award can be appealable under section 34, whereas in mediation, decree or settlement in terms of the settlement is final and non-appealable. That is what my friend just now told. In judicial process, no opportunity for the parties in communicate directly with each other, whereas in arbitration, no opportunity for the parties to communicate directly with each other. But because being in the arbitration proceedings, nowadays, both the parties are able to discuss between and argue between among them in the same forum, so that I think opportunity has given by section 30 of the Arbitration Act, where the mediation can be done even under section 30 during the proceedings of arbitration. This is what is the recent change in 2015 amendments of Arbitration and Conciliation Act. In the mediation, optimal opportunity for parties to communicate directly with each other in the presence of the mediator. Just think of, they themselves can decide in the mediation process, and the mediator will act as a catalyst and thus arrive for a solution. This is a wonderful method actually. In judicial process involves the payment of court, whereas in arbitration, arbitrator and refunded back. That is what Ashok from Chittur, the legal services secretary, who is a honorable judge, he how beautifully the mediation can be done. Yes. Telling that people do not know how to use the mediation. And also at the same time, he has been telling to me, you have to educate even the judicial officers, that is the judges also. Unless the judges refer the cases to the mediation, to the legal services authority, it cannot be success. I totally agree with you, my friends. And I will speak to your principal district judge and take some time out and come to the Chittur. Similarly, all over India, friends. Friends, until now we have been discussing about the judicial process, arbitration and mediation differences. Now I will take you through the differences between mediation, conciliation and lok adalat, because these are all part of the ADR methods. If you see, mediation is a non-adjudicatory process, whereas conciliation is a non-adjudicatory process. But whereas the lok adalat is a non-adjudicatory process if it is established under section 19 of the LSA Act 1987, and it is conciliatory. So the judge who acts as a president for the Lok Adalat hearing, he will be adjudicating your issue in the court premises established for that day under section 22B and LSA Act of 1987. This is also one of the wonderful method where the courts are following to resolve the issues in the court system under Lok Adalats. Mediation is a voluntary process and conciliation is a voluntary process. Lok Adalat is also almost a voluntary process. Mediation is a mediator who acts as a third party neutral, and conciliator is a neutral third party conciliator, whereas in Lok Adalat, presiding officer is a neutral third party. In mediation, service of lawyer is available, in conciliation is also available, and in also Lok Adalat. Friends, again, mediation, conciliation, and Lok Adalat differences. It is a party negotiated. Mediation is a party centered negotiation. That means both the parties can conclude themselves. It is an opportunity, great opportunity given by the courts to us. Even the private mediation, once it fall into the line, then this is also can be administered stage wise. In conciliation, it is a party centered negotiation, but the conciliator. In Lok Adalat, the Lok Adalat scope of negotiation is very limited. Why? Because the president of the Lok Adalat will be taking the decision on it. In mediation, the function of mediator is mainly facilitative, whereas in conciliation, the function of mediator is more active than the facilitative function of the mediator. In Lok Adalat, the function of presiding officer is persuasive. Whereas in the mediation, the consent of the parties is non-mandatory for referring similarly in the law, not referring mediation, it has been referred to the referral Arbitration and Conciliation Act 1996. In Lok Adalat, the award of the Lok Adalat is deemed to be decree of the civil court and executable under section 21 of the Legal Services Act of 1987. Friends, in finality, I have been bringing the differences between mediation and conciliation. Whereas in mediation, it is not available, whereas in conciliation, decree or order not available. And in Lok Adalat, award is also not appealable. Whereas the mediation focus of proceedings on very specifically on future. Whereas in conciliation, the focus of present proceedings will be on present and future. And in Lok Adalat, the focus of proceedings will be on past and future. Whereas in mediation, parties actively and directly involved, and whereas in conciliation, parties are actively and directly involved, but the decision will be taken by the conciliator. And in Lok Adalat, parties actively and directly involved, but the decision will be always taken by the presiding officer. In mediation, confidentiality is the essence in mediation, whereas in conciliation, confidentiality is the essence of conciliation. Whereas in Lok Adalat, confidentiality is not observed in the Lok Adalat. Friends, with this, a brief introduction on ADR methods I have been concluding. I will take few questions after 10 minutes. I will just in a fast track mode, I will take you through what are the recent amendments which has come in place in 2015 and 2019. After you can ask some questions. हाँ? अच्छा ओके వస్తాను చెప్పు టూ ఓ క్లాక్ కార్ పంపిణీ
2 o'clock and car ఉంటుంది 2 o'clock కి కార్ పంపిస్తున్నాం రవీనగర్ బిల్డింగ్ అండి గాంధీ భవన్ ఆపోజిట్ రవీనగర్ బిల్డింగ్ నంబర్ హలో
Friends, I will quickly take you through the recent amendments in the Arbitration and Conciliation Act, which is of 2015 and 2000. Friends, you may observe that in 1996 Act, there were few issues which have come up, which were teething problems for all the people, those who are using the Arbitration Act and Conciliation Act, where when the current government has come in place, there were only small investments were keep happening. So during that time, the current Prime Minister has taken a decision to take the views of many multinational companies, lawyers, judges, engineers, chartered accountants. So initially, when he has taken the oath as a Prime Minister, he has taken few decisions after consulting, and during the consulting process, few people have advised for the changes in the Arbitration Act, and thus 246th Law Commission has been appointed, and the arbitration amendments were brought into force in 2015, that is on 23rd 10 2015 onwards, with an ordinance from the central government. Friends, this act is called 3 of 2016, whereas arbitration is made into 4 parts. That is, first chapter, 10 chapters deals with 1 to 43 section, and whereas the second 2 chapters, that is section 44 to 60, and the part 3 conciliation from section 61 to 81, and part 4 section 82 to 86. So friends, there are various schedules also which have come in place in 2015 and 2019 Act, where the convention and recognition of enforcement of arbitral award has been formed under Schedule 1, and under Schedule 2, the protocol on arbitration clause has been declared, and also Schedule 3, convention on execution of foreign arbitral awards were given in the Amendment Act under Schedule 3, and Schedule 4, the model fee applicable for arbitration has been put in place in the Arbitration and Conciliation Act. Schedule 5, which is very, very important, grounds for determining justifiable doubts as to independence or impartiality of the arbitrator. This is very, very important. So partiality, impartiality through disclosures of the arbitrator before he gives an
Hello, sir. అశోక్ ఒకసారి సార్ కాల్ చేయండి, నెట్వర్క్ ఇష్యూ వచ్చినట్టుంది అక్కడ.
సార్ చేస్తున్నా సార్.
ఏమైనా పవర్ ఇష్యూ ఏమైనా ఉందా?
He's been appointed as an arbitrator can be taken care, and this is one of the big good amendment which has come through 2015. At the same time, an amendment aiding reducing the judicial intervention. Yes, earlier the judicial officer
Hello, sir. One minute అండి, సార్ని కాంటాక్ట్ చేస్తున్నాము. ఐ థింక్ దెర్ ఇస్ ఎ నెట్వర్క్ ఇష్యూ.
Okay, sir.
హలో సార్. మూర్తి సార్.
ఆడియో ఫెయిల్. రావట్లేదు సార్. వాయిస్ రావట్లేదు. సార్.
5 minutes అండి. సార్ నెట్వర్క్ ఇష్యూ కనెక్ట్ అవుతున్నారు మళ్ళీ. హలో సార్, మూర్తి సార్.
Are you able to hear me, sir?
Yes, sir. Yes, sir. Now audible, sir.
Okay, good. Thank you very much. I could not be able to more largely explain on the arbitration amendments, but I think I will be able to take few questions now. Few questions, please.
Good morning, sir.
Tell me.
Good morning, sir. Na per Kaushalya. I'm the
Tell me,
student.
good afternoon.
Okay, sir. Sorry, sir. Good afternoon.
Cheppamma.
సార్ యాక్చువల్ గా ఏడిఆర్ ప్రాసెస్ అనేది టైం సేవింగ్, మనీ సేవింగ్ అండ్ ఫాస్టెస్ట్ ప్రాసెస్ సార్ కంపేర్ విత్ ద లిటిగేషన్. ఏంటి మీరు చాలా అవేర్నెస్ క్యాంపెయిన్స్ అనేవి పెట్టారు, అయినా ఎందుకు సార్ డెవలప్ అంటే ఏడిఆర్ అనేది డెవలప్ అవ్వట్లేదు? యాక్చువల్ గా లిటిగేషన్ లో చాలా అన్ని కోర్ట్ కేసెస్ అనేవి పెండింగ్ ఉండిపోయాయి. సో ఇది ఫాస్టెస్ట్ ఏంటి ఏడిఆర్ అనేది డెవలప్ అయితే మనకి చాలా వరకు కేసెస్ అనేవి పెండింగ్ నుంచి అంటే రెడ్యూస్ అవుతాయి సార్. అంటే ఏం జరుగుతుంది అంటే అంటే అవేర్నెస్ అనేది జనాల్లో లేకపోవడమా ఏంటి సార్?
అవునమ్మా, నువ్వు మాట్లాడింది కరెక్ట్ గా మాట్లాడావమ్మా. చాలా వరకు ఏంటంటే అవేర్నెస్ లేదు జనాల్లోకి. ఆల్టర్నేట్ టు ది డిస్ప్యూట్ రిజల్యూషన్ అనేది కోర్టులో పెరిగిపోయిన కేసెస్ ని బయట కూడా మనం వాదించుకోవచ్చు, దాన్ని మనము ఇచ్చేసుకోవచ్చు అని చెప్పి చాలా మందికి తెలియదు. ఫర్ ఎగ్జాంపుల్, if you go to Singapore, if you go to Hong Kong, if you go to small countries, adopting the ADR methods first and then they are using the litigation process. కాబట్టి మీరన్నట్టు ఈ పర్టికులర్ ప్రోగ్రామ్ జరగడానికి కూడా నిన్న మొన్న మేము న్యూస్ పేపర్లో కూడా వేయించాల్సి వచ్చింది. అంటే ఈ పర్టికులర్ మెథడ్స్ ని యూసేజ్ చేయడానికి జనాల్లోకి, అదే అన్నారు అశోక్ కుమార్ గారు, లీగల్ సర్వీసెస్ సెక్రటరీ గారు, అదే విధంగా ఇంకొక సెక్రటరీ గారు కూడా, ఇది ప్రజల్లోకి వెళ్ళాలా, ప్రజలకి చాలా చెప్పాలి. ఇప్పుడు ఈ పాండమిక్ సిచ్యువేషన్ వచ్చింది కాబట్టి, కోవిడ్ సిచ్యువేషన్ లో మనమందరం ఈ జూమ్ ద్వారా ఈ సబ్జెక్ట్ గురించి నేర్చుకోగలుగుతున్నాము. కానీ ఇది వరకు లేదు కదమ్మా ఈ ఆప్షన్. కాబట్టి ఎస్, I agree with you. This need to be propagated more in the people, and people will be able to usage. At the same time, specialized people in these particular categories in the arbitration and mediation need to be trained. So don't worry, madam. To last 5 years, which I have seen after my demising from my office of General Counsel, the 5 years there was a phenomenal growth. So that means people will learn, and very specifically in this pandemic situation, it is going to improve.
Okay, sir. Thank you,
sir. Good morning, sir. I'm P. Srinivasa Rao from Rajahmundry. Good afternoon, sir. I'm P. Srinivasa Rao from Rajahmundry, accredited mediator and trainer by NCPC, Supreme Court of India. Both Murthy garu and yourself enlightened us in the ADR methods, very vivid manner, and moreover, at the ground level, the ADR system is not attracted by the common people. So we have to make all the platforms like media, TV, and online methods. Why? Because nearly 3.5 crores of cases are pending in the judiciary all over the country. So
yes,
the ADR system is economic, not time consuming, flexible. So we are all work together to minimize the pending in the courts. Thank you very much, sir, for giving me this opportunity.
Thank you, sir. Thank you for your feedback.
Thank you, sir. Thank you. Thank you.
Hello.
Yes, madam.
Hello.
Yes, madam.
Hi, sir. Good afternoon, sir. I am Jaya Indra Patel, advocate, mediator, trained mediator through Supreme Court. Now we had trained in online also as a mediator, and I am speaking from Tamil Nadu, sir. Actually, in this process, it is a short span. Already I had spoken to sir at morning itself. It is a short span process and economic time save also. And not only as a mediator, it is a confidential process. Whereas in a short span, we can approach by way of confidentiality. We can, as a facilitator, we can train the people also to solve the problem. So, and what my suggestion is, sir, after going to the court, prior to the litigation started, immediately after filing the case in the court, it can be sent to the mediation. If it has been this primary step has been taken, means it can be solved so many cases, sir, which has been adopted through all over the world. Outside the countries also, they are adopting in Australia, Canada, Japan, in all these countries, they are adopting.
Where we need to also propagate this particular mediation.
Yes, sir. Yes, and now, as per sir has given good ideas, and you had given good suggestions and so many points, and now it has to be practically applicable to our country. It has to be, the steps has to be taken in an effective way. So then it will be helpful for the whole village peoples and all over country also, it seems, sir. So my suggestion is, it is a very good process in which where the problem has been, litigation has been disposed in a quick disposal way, yes, sir, in these process. It's my ideas.
I agree, madam.
Okay,
I totally agree with you. I totally agree with you. And we will also, your suggestions are well taken.
Yeah, yes, sir. And it is a win-win process, whereas no appealable and economic time, everything has been saved also. It is a good process. It is a good old traditional process, sir. Actually, it is a past, the history. If we came to know about, means it is a old panchayat form. So it is a good method to solve the problems in a quick and speedy method, sir. Thank you, sir. Thank you very, very much for giving this opportunity, sir. Thank you.
Sir, good
Once
afternoon,
again,
sir. This is Amulya, advocate.
Yes, please.
సార్ ఇది ఓకే ఆర్బిట్రేషన్ అంతా ఓకే సక్సెస్ఫుల్ గా ఉండాలి అంటే అసలు మీడియేషన్ సెంటర్స్ అనేవి లేవు సార్ అసలు చాలా చోట్ల. యాక్చువల్ గా ఏంటి అంటే సార్ చెప్పు
అమ్మ, మీరు అన్నట్టు మీడియేషన్ సెంటర్స్ కంపేర్ ప్రీవియస్ టైం కన్నా ఇప్పుడు కొన్ని వస్తున్నాయమ్మా. ఒకటి ఏంటంటే ప్రతి స్టేట్ గవర్నమెంట్ కూడా దానికి బడ్జెట్ ఏర్పాటు చేయాలా టు ద హై. కాబట్టి కంపేర్ టు లాస్ట్ 5 years the phenomenal growth is there on the mediation centers. Yes, in the district courts the mediation centers are there, and now we need to take it to the taluks and musafils. Yes, I agree with you, but yes, it will take care, and in due course in the musafils also the mediation centers will come. Madam, we wish that we will all work together in the musafils also in future.
సార్ అయితే ఏంటి అంటే కనీసం ఆర్బిట్రేషన్ చేయడానికి ఒక 2 persons అడ్వకేట్స్ నుంచి తీసుకొని వాళ్ళకి ట్రైనింగ్ ఇస్తే బాగుంటుంది. ఎందుకంటే అదర్వైజ్ అది పాసిబుల్ కాదేమో. అంటే బయట మీడియేటర్స్ ఎక్కువైపోతున్నారు.
తప్పకుండా అమ్మా. మీరు ఏ డిస్ట్రిక్ట్ నుంచి అమ్మా? మీరు
గుంటూరు డిస్ట్రిక్ట్ నర్సరావుపేట సార్.
తప్పకుండా నెక్స్ట్ టైం నేను గుంటూరు అప్పుడు మీ పేరు తప్పకుండా నేను గుర్తుపెట్టుకుంటాను. తప్పకుండా మీలాంటి వాళ్ళని తప్పకుండా నేను యాడ్ చేసుకుంటానమ్మా.
ఓకే సార్, థ్యాంక్ యూ వెరీ మచ్.
Thank you very much. Sir, any more questions? Any more questions?
Hello?
చెప్పండి సార్. హలో సార్ చెప్పండి. హలో సార్ చెప్పండి.
సార్ గుడ్ ఆఫ్టర్నూన్ సార్.
హలో సార్. హలో చెప్పండి.
గుడ్ ఆఫ్టర్నూన్ సార్, నేను రవిచంద్ర మాట్లాడుతున్నాను సార్.
హలో. ఎస్,
గుడ్ ఆఫ్టర్నూన్ సార్. సార్ గుడ్ ఆఫ్టర్నూన్.
సార్,
my name is P.V. Narasimha, advocate from Kottapeta, East Godavari district.
చెప్పండి సార్. చెప్పండి సార్. హలో
సార్.
There is some connectivity problem.
Sir, good afternoon, sir. I am Ravichandra sir. Sir, good afternoon, sir. Sir, Ravichandra మాట్లాడుతున్నాను సార్.
చెప్పండి.
సార్ మాది అనంతపురం డిస్ట్రిక్ట్ సార్. విజయనగర్ లా కాలేజ్ స్టూడెంట్ ని అండ్ ఆల్సో పిఎల్బి పారాలీగల్ వాలంటీర్ సార్.
చెప్పండి సార్.
సార్ ఇప్పుడు మీడియేషన్ అన్న సెల్ ని ఒక అనంతపురం డిస్ట్రిక్ట్ లోనే కాకుండా సర్టన్ టౌన్స్ లో కూడా ఏర్పాటు చేసి కొంతమంది మెజారిటీ ఆఫ్ ద అడ్వకేట్స్ కి మనం సలహాలు ఇచ్చి సూచనలు ఇచ్చి వాళ్ళతో పాటు ఈ సిస్టమ్ ని డెవలప్ చేస్తే జ్యుడిషియల్ ప్రాసెస్ వల్ల కొంతవరకు రిలాక్సేషన్ గా ఉంటుంది కదా సార్ పార్టీస్ కి అనేది నా ఉద్దేశం సార్.
సార్ కరెక్ట్ చెప్పారు మీరు. నేను ఒప్పుకుంటా మీ విషయంలో. కానీ ఒకటి వెరీ ఇంపార్టెంట్ అండి, మన బార్ అసోసియేషన్స్ కూడా దీంట్లో పాల్గొనాలి. మీ బార్ అసోసియేషన్ కన్సర్న్ బార్ అసోసియేషన్ ప్రెసిడెంట్ గారితో మాట్లాడి ఒక హాఫ్ డే ప్రోగ్రామ్ మీ బార్ అసోసియేషన్ రూమ్ లో కండక్ట్ చేయండి. నేను హైదరాబాద్ నుంచి వచ్చి నేను ట్రైనింగ్ ప్రోగ్రామ్ కండక్ట్ చేస్తానండి.
థ్యాంక్ యూ సార్. థ్యాంక్ యూ వెరీ మచ్ సార్. థ్యాంక్ యూ సార్.
థ్యాంక్ యూ అండి. నమస్తే అండి. I think with this, I think the program concludes now, and I request the organizers to take up.
Thank you so much, sir.
Thank you.
Thank you so
Thank
much,
you,
sir,
sir.
for
Thank you very
sharing
much,
your
sir.
valuable presentation. The detailed explanation.